Hello again, and thank you for stopping by. On our first episode of Hey, Did You Know? I will be discussing some hot topics in family law, more specifically child custody and visitation. COVID 19 has caused some significant concerns and issues for all of us. More specifically, more and more people are finding that COVID 19 has raised some issues regarding their child custody and visitation rights. So, this video here is to answer some of the most common questions that I've received in recent weeks regarding child custody and visitation. The first question I've received is, can the custodial parent use the pandemic as an excuse to deny visitation? Well, the short answer, no, they can't. But let me elaborate a little bit. To understand, the pandemic has definitely been the cause for health concerns, and it is 100% understandable. However, parents and guardians are still parents and guardians, and the 6-foot social distancing requirement does not apply to them. However, if there is a chance that either parent has come in contact with the virus, of course, both parents have the duty to let each other know. And if the child must be quarantined for 14 days, both parents need to be informed, and it is important that all tests and test results are given and communicated to each parent. And parents, if you must quarantine, please quarantine just to stop the spread. There is no need of exposing your children to the virus, as is both selfish and counterproductive. Another question, should I say, that I have received is, should I make a visitation schedule? Far too often, I'll say, parents agree to this statement of reasonable right of visitation. Please, don't do it. It's a setup. Now, you may be wondering, Krista, what you mean it's a setup? Well, let me give you an example. Let's say, for example, two parents are in court for child visitation issues, child custody and visitation issues, should I say. And in most cases, unfortunately, parents don't agree on the visitation schedule, and so they end up having to go to court. And usually in court, it is decided on who would be the primary custodial parent. And then on the other side of things, the custodial parent usually will convince the non-custodial parent that there's no need for a schedule, and that I will allow you to see the child whenever you want to see the child or children. And all will be well at the beginning anyway. But then the parents have falling out, and suddenly the visitation stops. And the non-custodial parent is left with nothing because they don't have a schedule, just a statement that says reasonable right of visitation, which unfortunately means that the non-custodial parent must go back to court, where he or she could ask for a specific schedule, which does nothing more, honestly, than cause you to waste more time and money in some instances, and especially, more specifically, time away from your children. In either of these cases, ladies and gentlemen, please, it is important that you consult with an attorney to assist you with this and make sure that it's done right the first time. It's nothing more frustrating than going to court with an attorney after you've already made all of these decisions, you've signed all of these papers, you've done all these things, and then you expect the attorney to come in and to fix it. So in these cases, in either case, whether we're talking about a COVID-19 issue or a child custody and visitation issue, you want to consult an attorney. Well, that's all I have for this episode. I hope this video was informative and answered some of your questions, maybe gave you a little clarity on some issues that you had, and I'll see you next time, where I'll be covering another hot topic and answering some more common questions that I've received. So Until next time, you have a great one.